Hello. Welcome to this season's seventh episode of Schwegman, Lundberg, and Woosner's Chemistry and Biology Seminar Series. I am Nicholas Lanzatella, your moderator for the series. Welcome. I'm so glad you joined us today. During this series, attorneys from the SLW law firm having a background in chemistry or biology will present on various topics at the intersection of the chemical or biological sciences and patent law. We will aim to give these presentations on the second Tuesday of each month. If you attend three or more of these presentations live and you have a mailing address in the United States, we will send you a free gift. Slides for today's presentation will be available in the chat, and a link will also be emailed to you. As a reminder, nothing in today's presentation should be regarded as legal advice. If you are seeking legal advice, please consult your legal counsel. I'm pleased to introduce our speaker for today, John Swart. John is a patent attorney that prepares and prosecutes patents in several fields, including electrical, biomedical, software, mechanical, and chemical technologies. Additionally, John prepares freedom to operate opinions and manages portfolios for several small to mid-sized clients, including counseling and diligence support for tech startups from conception to sale. John has a bachelor's degree from Northwestern College in biology and a law degree from Mitchell Hamlin School of Law. Today's presentation is titled Modern Induced Infringement, Evolving Standard Based on Recent Supreme Court Decisions. If you do have questions, and I encourage you to ask questions, please put these in the Q&A box, which is at the bottom of your Zoom window, and John will answer these during or after the presentation. Again, it's preferable if you put those questions in the Q&A box instead of the chat. All right, take it away, John.
Thanks, Nicholas. Thank you for joining this webinar. I guess the impetus for this topic is a recent case that's gotten to the Supreme Court that's a pharmaceutical case. There's been a string of cases that we'll talk about, but they all sort of revolve around this topic of induced infringement. And I thought it timely and interesting to maybe go over what has happened in the courts and what is maybe about to happen in the courts regarding this topic as it pertains to both the chemical arts, but also as to just patent law as a whole. Um, so let's start talking about just what induced infringement is and where it comes from statutorily. So induced infringement is a provision of patent law that um, implicates someone who maybe doesn't uh, fulfill every step of a method claim in in an infringement case. So uh, basically, the as the statute says, whoever actively induces infringement of a patent shall be liable as an infringer as well. So this is a pretty short provision in the statute, and courts have had the burden of interpreting this for several years now. So we have several cases, some of which, are not worth discussing in detail, but I have a few quotations here. One of them, Metro Goldwyn Mayer Studios v. Grogster. The Supreme Court held that mere knowledge of some customers, there's a possibility they might infringe. That's not sufficient. There must be clear expression or other affirmative steps taken to foster that infringement. And in WebTech Appliances v. SEB, the Supreme Court also interpreted that the statute requires affirmative steps to bring about the infringement. So historically, the Supreme Court especially has made induced infringement, they've kind of avoided it becoming this passive step where someone's customers, without knowledge, without any encouragement, or any affirmative steps to fostering the infringement. Generally, the Supreme Court has moved away from policy that holds manufacturers or other corporations liable for what their customers might be doing. So, as interpreted both by the Supreme Court and the Federal Circuit, generally, infringement must involve five elements. So, the first, the defendant must know of the patent or be willfully blind to its existence. Second, the defendant must have specific intent to encourage the infringing acts. This comes from Camille USA versus Cisco Systems, where the Supreme Court determined that induced infringement requires proof that the defendant knew that the acts were infringing and intended to encourage them. Three, the defendant must take affirmative acts of encouragement. So merely selling the product and knowing it could potentially be used in an infringing way is not enough. Four, an actor must actually perform the patented method. This is important. It means that someone must be the direct infringer. And this sort of this point four maybe differentiates from other doctrines of patent law and statutory um, infringement sections that require like divided infringement is something that maybe doesn't require a single direct infringer. In induced infringement, we actually do need someone is a direct infringer. And then this is just to implicate another party for being on the hook for that direct infringement as well. And the fifth point, there must exist a causal connection between the defendant's inducing acts and the direct infringement. So this comes from the Federal Circuit. They've held that inducement requires proof that the defendant's actions actually led to infringement. And this comes from Power Integrations v. Fairchild Semiconductor back in 2016. So there have been sort of ample interpretations of this section of patent law. Today's topic, I would say, where this intersects, especially with the chemical arts, is a a newer issue. So in 1984, the Drug Price Competition and Patent Term Restoration Act was passed. This is better known as the Hatch-Waxman Act. Um, so this was sort of an act that had a ton of new provisions regarding drug innovation, drug affordability. It's generally, so for some background on how this integrates with patent law, generic drugs must have package inserts that are identical to their branded counterparts. This is generally facilitated by the FDA and required by the FDA. So if a branded drug is protected by a patent, then a generic company may not lawfully sell that drug unless it proves that the patent is invalid or that its generic product won't infringe. Um, so on the other side of that same idea, if a brand company's patents cover all of its drugs FDA approved uses, the generic's packaging insert must recite the same patented uses. Now, where the Hatch-Waxman Act sort of comes in is it provides an exception to the generics package insert um, if at least one FDA approved use of the branded drug is unpatented. A generic can avoid patent infringement liability and also obtain FDA approval by carving out the patented uses from its package insert. So this is, I think, probably the goal here with introducing this carve out was to balance facilitating generic drug entry into the marketplace and but also in ensuring that patent holders can continue to be incentivized for innovating in new medicines. Um, what might not have been completely foreseen is the effects of this provision on the doctrine, the court's doctrines and interpretations of induced infringement, which is sort of what brings us to our topic today. So let's return maybe to this Section 8 of the Hatch-Waxman Act that carves out um, this provision for generic drug manufacturers. So a generic manufacturer may certify that its proposed labeling does not include any indication covered by a listed method of use patent. The FDA approves the abbreviated new drug application. So this is called, abbreviated as ANDA, with labeling that it carves out certain patented uses. Unlike paragraph 4, certifications that challenge patent validity, Section 8 statements do not trigger a 30-month litigation stay. So this expedites generic entry into the marketplace. This is important. Um, so maybe to sort of frame up the issue, um, because I'm going to walk through some cases throughout the presentation, and rights holders on both sides of the brand and the generic um, side of the coin, they've made clever arguments in either direction. And I think at the end of the presentation, I hope to have some sort of discussion, maybe with some comments in the chat about how the current case that's in front of the Supreme Court might turn out. But just to give the whole issue some context, doctors generally will prescribe drugs for off-label uses. This is just how doctors tend to prescribe. And at the point that they're prescribing, they don't see the generic manufacturer's FDA-approved labeling when it comes to writing prescriptions. Um, they also are not the ones fulfilling those prescriptions, that's the pharmacists. So in certain jurisdictions, in the US at least, pharmacists actually must dispense a generic unless the prescriber explicitly requires the brand. So what you end up with is doctors prescribing drugs, um, and not taking any of this carve out into consideration. Um, I don't know if this was contemplated in the formulation of the Hatch-Waxman Act back in 1985, but this is definitely, um, as far as I have been made aware, how this industry operates. So, you might be starting to tell, as I'm setting this up, that this creates some issues because basically a generic manufacturer can possibly, depending on what market they're coming into and what they anticipate will be the behavior of the doctors prescribing the drugs and the pharmacists fulfilling the drugs, is they might be able to comply with this Section 8 carve out, but not have the doctors that are prescribing and the pharmacists fulfilling the prescriptions actually abide by the intent of this carve out. And thus, the generic could be prescribed and used for something that is patented while not maybe directly fostering that connection themselves in their marketing and certainly not with their label. So the question, to kind of frame it up squarely, is will a skinny labeled generic be used to infringe a patent of a name brand drug? Um, as we've said, generics are required by the FDA to mimic a brand's label. It's not even that they're being tricky. It's the only way that they can get approval in some cases. And so the question is a defendant intentionally inducing patent infringement by saying something that a government agency has required them to say? Generic companies must, in these situations, they might be arguably trying to avoid encouraging infringement of a patent, of a third-party patent from a name brand drug by convincing the FDA to allow them to remove from their label language referencing the patented method. So, sort of the policy decision is between the generic manufacturer. They would prefer that a skinny label provides them full immunity from patent infringement on their Section 8 carve-outs, including the right to collect profits on sales that might end up being used for the patented indication. And of course, on the other side, the branded manufacturer would ideally like to use its patent to block the generic from the market entirely. At least that's what we've seen branded manufacturers pushing for, and that's maybe the whole purpose of this section in the Hatch-Waxman Act is to prevent this sort of monopolization of certain drugs via patents. So if we rule in favor of the generic companies in some of these fact patterns that we'll walk through shortly, this will weaken method of use patents. Um, and if we rule in favor of the brand, we sort of provide patent holders a way to extend their monopolization over what the patent was originally intended for, uh, maybe along to unpatented uses. So it is actually quite the dilemma. Um, this was first visited by the Federal Circuit or reviewed by the Federal Circuit in GlaxoSmithKline v. Teva in 2021. So I'll just briefly walk through this case, the fact pattern of this case. Um, Involved carvedilol, a heart medication, under the brand name Coreg. The FDA had approved this drug for three uses. It had approved it for hypertension, treatment of congested heart failure, and to reduce cardiovascular mortality in patients um, suffering from left ventricular dysfunction. Um, GSK owned a patent on the method for using carvedilol to treat congestive heart failure. Teva, which would be the generic here, filed a Section 8 statement that its label would not include congestive heart failure indication. FDA approved drug label initially included only two indications, hypertension um, and um, post-MI-LVD. So for 4 years, Teva launched its generic without this congestive heart failure indication. And this is kind of unique to this case and maybe a whole separate issue that was a hot topic in this case. But the FDA actually instructed Teva to revise its drug label to be completely identical to GSK's. Um, so to remove the Section 8 carve out, and Teva in turn changed its drug label um, by instruction from the FDA to include the congestive heart failure indication. So the Federal Circuit upheld the jury verdict in favor of GSK that even though the generic, and this is for both the time period that the Section 8 carve out was active and after when the label matched the brand name drug. Even though that the generic had carved out its label, um, it was infringing on GSK's patent. Federal Circuit reasoned that Teva's partial label encouraged an infringing use um, that via the post-MI-LVD indication that remained on the label. And they also took into account Teva's marketing materials in their sale of the generic drug. So this was a pretty big Federal Circuit ruling. It had major implications on generic's path to market via this Hatch-Waxman Section 8 carve-out. And it sort of ended the notion that maybe had been present before this case, before this ruling, that the Section 8 carve-out could give generic holders immunity from patent infringement, even if they very well knew that they were entering a market that was primed for their generic off-label use to infringe a third-party brand name patent. So, I mean, on the tail end of this case, what um, might be interesting is Teva did file for certiorari with the Supreme Court, and the Solicitor General actually recommended Supreme Court granting review, which the Supreme Court generally does grant review in these cases at the recommendation of the Solicitor General. Here they did not. So that was the end of this case. So, I mean, just to summarize, GSK sort of established a new theory of induced infringement based on um, instead of sort of express instructions to customers to engage in patented activity, um, but merely based on the package insert language and the interpretation of that in light of marketing materials, and in spite of the Section 8 carve out via the Hatch-Waxman Act. So, and I'm getting somewhere with this because um, the case at hand right now that's currently in front of the Supreme Court, all of these previous rulings, I think, inform how we're supposed to speculate on what's going to happen in the current case, which is Amarin v. Hikma. But I just want to walk through these other cases first, just to give some context and set the stage. So GSK v. Teva 2021 rule in favor of the patent holder, the brand name. Now, this is a ruling, I believe, in March. Yeah, March 25, 2026. So very recent. This is actually a copyright case, but I'll explain why I think it's relevant to discuss here first. So, Cox Communications versus Sony. It was a case regarding whether an ISP, an internet service provider, can be held liable for contributory copyright infringement for continuing to provide internet access to subscribers that it knew were infringers to third-party copyright holders. Um, Now, they didn't have proof of specific affirmative conduct to promote the infringement from the ISP, but basically, the fact pattern in this case is that Cox Communications knew that hundreds of members on their service were regularly infringing copyrights, and I think they only suspended 16 accounts or something over the course of several years of this knowledge. Now, what does this have to do with patent law? What does this have to do with pharmaceuticals, the chemical arts? Well, I guess if we rewind back to when I was talking about induced infringement right away. Um, so, Copyright Act does not actually include any language regarding induced infringement or contributory infringement. So, the courts have generally analogized and compared copyright law to patent law in talking about induced infringement and copyright and contributory infringement and copyright. And they've actually done that here. This 2005 case, Grokster, was actually a copyright case that produced good law that has been taken in uh, subsequent cases to be applied to patent law. And so there is good reason to believe that the outcome, the Supreme Court outcome here, has some implications on patent law. Um, yeah, and this is just restating that basically there's a few cases that we've kind of compared patent law's contributory infringement inducement statutes into copyright law and discussed them as if they were sort of parallel. If nothing else, though, this case and this outcome might provide a bit of insight as to where the courts are leaning, where the Supreme Court is leaning right now in terms of expanding these doctrines of contributory infringement and inducement. So here, the Supreme Court just a couple of months ago reversed the verdict against Cox Communications, holding that an internet service provider could not be held contributorily liable for its users' copyright infringement simply because it knows about the infringement and continues providing service. So, I mean, if nothing else, this indicates that the present Supreme Court is skeptical about expanding secondary liability beyond these 5 points that we discussed from Supreme Court cases and Federal Circuit cases. So what does this mean for skinny labeling and the current issue at hand in Amarin v. Hikma? So this is a case just weeks ago. We had oral hearings in the Supreme Court, which we'll walk through. But this is a case regarding Vascepa, which is brand name of icosapent ethyl. It is a fatty acid EPA derived from fish oil. It was FDA approved in 2012 for treating hy hypertrip hypertriglyceridemia, condition marked by dangerously elevated blood fat levels. So, um, Amarin secured a label expansion for cardiovascular risk reduction based on a study showing that Vascepa reduced heart attacks and strokes, even in high-risk patients that were already taking statins. So this was basically a new use for an existing drug that was already patented. So here, Amarin is the brand name. Hikma is the follow-on generic manufacturer. So also in 2019, same time period as this new discovery of new use for old drug, Hikma obtains FDA approval for generic version of Vascepa using a Section 8 carve-out. So um, Amarin sued Hikma for actively inducing patent infringement based on the Section 8 carve-out skinny label and um, sort of also included um, arguments that Hikma's press releases referring to its product as AB generated and a generic version of Vascepa were inducing their customers to encouraging their customers to toward off-label use. So the 537 patent, the 861 patent, they're directed to methods of using icosapent ethyl to reduce risk of cardiovascular events. These are the patents, um, the standing patents. Amarin actually had also originally held method of use patents for the previous SH and CV indications. These patents were invalidated, leaving only the CV patents. So this is kind of a unique fact pattern, maybe even more blatant than the GSK fact pattern, where you have a brand name rights holder having patent rights to only the CV patents and the CV indication, but not the SH, um, which leaves a wide open window for a generic holder like a generic drug manufacturer like Hikma to use a Section 8 carve out for the SH indication where there is no patent protection. Even if Hikma knew about a potential use for their drug for CV, which was the patented use from Amarin. So, while Hikma carved out the CV indication and labeled its product only for the SH use, the generic we've seen is regularly prescribed and used for the infringing CV indication. So the question that this case and the fact pattern kind of screams is, can a generic drug manufacturer be liable for induced infringement when using a skinny label that carves out patented uses. So here's how the case has gone so far. In February 2022, District of Delaware dismissed Amarin's complaint for failure to state a claim based on the fact that Hikma had complied with the Hatch-Waxman framework and that no specific statement encouraged the patented use. The Fed Circuit, though, 2 years later, actually reversed this decision and acknowledged that Hikma's label did not instruct infringement, but found that the allegations taken together plausibly stated a claim for induced infringement. This is 2024, so only 3 years after the GSK decision. Um, I think we've seen it's probably worth, before I get completely into Amarin v. Hikma, um, s- just mentioning that the GSK case led to, I want to say, two or three other Federal Circuit rulings that had similar outcomes. I don't think that they were worth walking through the fact patterns in this presentation, but I think it's worth noting that this was not an isolated ruling and that it was sort of a fact pattern that we were seeing around this time period with generic manufacturers and certain brand name patents expiring, certain brand name patents being invalidated, and there being this window of opportunity for generic drug manufacturers to use Section 8 carve out, knowing that the um, actual use uh, by the prescriptions will be for a patented use, even though they've carved that out of their label. So, Federal Circuit in this time period, 2021, and even through the case at hand, 2024, is generally deciding in favor of the brand name drug manufacturer and sort of implying that the Section 8 carve out of the Hatch-Waxman Act is not a viable um, way for a generic manufacturer to avoid or have immunity of patent infringement if that's sort of what ends up happening. They are still on the hook for induced infringement, is sort of what some of these cases imply. What has been interesting, though, unlike the GSK case, the Supreme Court actually did grant certiorari here. Again, Solicitor General submitted a brief that challenged the views of the Federal Circuit, just as the Solicitor General did in the GSK case. So in both of these cases, the government is providing input. Now it is in front of the Supreme Court um, to address the issue and maybe interpret the Federal Circuit's decisions or reverse their decisions. And just a couple weeks ago, April 29, 2026, the Supreme Court held oral hearings for this case. So this is from the writ of certiorari. This is question from petitioner Hikma. Two questions. When a drug label fully carves out a patented use, are allegations that the generic drug maker calls its product a generic version and cites public information about the branded drug enough to plead induced infringement of the patented case? And two, does a complaint state a claim for induced infringement of a patented method if it does not allege any instruction or other statement by the defendant that encourages or even mentions the patented use? So here, the fact pattern, I think a big difference between this case and GSK is that um, while there are marketing materials that are talking about um, Hikma's generic being the generic version of Vasepa and the similar time frame for the discoveries for the new use, the new cardiovascular use, and when Hikma obtained FDA approval with the Section 8 carve-out, there were no marketing materials that instructed or implied that the generic was useful for the patented CV indication. So Hikma is asking the courts to interpret once and for all this Section 8, maybe you could call it a loophole or a potential loophole for generic holders. Um, I guess calling it a loophole is maybe interpreting the case a little bit in favor of the brand holder because, on the other side of this, as we discussed with the policy considerations, is that here, based on the FDA submission, Hikma has sort of complied with everything, and in fact, in their label, they've maybe even instructed against patent infringement and instructed toward the non-patented indication directly. Um, so kind of an interesting case, an interesting setup here, but very similar in all other respects to the case at hand in GSK. So, here's just a few things I took from the oral argument that happened a couple weeks ago. So there were expert witnesses for both Amarin and for Hikma. The Solicitor General was also present, arguing on behalf of the government. Also worth mentioning that this case has elicited several amicus briefs from law associations and other third parties in the U.S. that provided a ton of input as to the policy considerations and the considerations of interpretation of law here. The oral argument, I mean, there's just a few things that I think were interesting. So everyone was looking at this case in the months preceding the oral argument, and when this was sort of granted back in January, I think it was January. Yeah, January, the Supreme Court granted it. We were hoping for some sort of explicit interpretation of the issue and possibly some creation of new law on the doctrine of induced infringement. And we at least saw one justice in the oral argument expressing that this is unnecessary, that they don't need to create any new doctrine, or they don't. Um, in the oral argument, they kind of implied that they don't need to even correct the decisions, the multiple decisions following GSK from the Federal Circuit to decide the case. There was some pushback on that, though, I think, because um, I think in responses, several justices expressed doubt over whether this should have been granted in the first place. Um, as the Supreme Court generally doesn't hear cases based on resolving factual error review. So, um, the Solicitor General provided some more input here. They argued that a strong case of active inducement would only arise in the case of here two hypotheticals. If Hikma had paired its generic Vascepa indication with the statement Vascepa is approved to treat cardiovascular risks in the same breath. And it did not. Hikma did not have marketing materials that in any way provided an indication that Vascepa is useful for treating CV. Um, or I guess they didn't say that the generic was, and they did not emphasize that Vascepa, the brand name of their generic drug, was approved for cardiovascular risks. So, Solicitor General is providing input saying, well, in this situation, one, yes, I could see this is more like the GSK situation, this hypothetical one. When this is not the case, Solicitor General is arguing seemingly on behalf of the generic drug manufacturer. The second hypothetical, if a generic asserting that studies have shown that icosapent ethyl reduces cardiovascular risks. I think there was some evidence that two is maybe a little bit more plausible or a little bit closer to any sort of marketing materials that were released. I don't remember the specific marketing material that was, this is the second hypothetical is not the case here. Hikma did not assert that studies have shown that icosapent ethyl reduces cardiovascular risks, but I think that based on the timing and the where these drugs were marketed and everything, I think if there's any argument here in favor of Amarin, it would be sort of closer to this second hypothetical, where even the Solicitor General has conceded um, that this would be a case for active inducement. Um, yeah, I think that's just what this point here is saying. Is basically the argument that Amarin is maybe trying to capitalize on is this timeline. All these new papers are coming out in 2019, um, and studies showing this new unexpected use for an existing drug. And right on the heels of that, Hikma is obtaining FDA approval and marketing a generic version of Vasepa, which implies um, that it could be useful for CV, even if that was not explicitly stated. So, now maybe we're into a bit of a discussion section of the presentation and talking about the implications of this case on skinny labeling, on the pharmaceutical industry, on patent law as a whole. Um, so, in my opinion, I think based on previous similar Supreme Court cases, it's unlikely that they will create a specific inducement doctrine for pharmaceutical and the chemical arts alone. That would be isolated from the rest of patent law. So I guess what I'm saying is whatever happens here will not only affect the pharmaceutical industry, but will likely um, have at least some tangential effect on how induced infringement is interpreted and applied in other arts. Um, Supreme Court might clarify the Federal Circuit's totality approach in the GSK's and the progeny of GSK cases, the string of Federal Circuit cases that sort of weighed all the facts and determined based on that fact finding whether they thought that induced infringement had occurred, which would be helpful because I think that those cases were very fact pattern specific and um, if anything, there maybe seems to be, or it could be argued that there is a discrepancy between what is outlined in the Hatch-Waxman Act and what is required to be FDA compliant as a generic drug manufacturer, and what the Federal Circuit has um, determined that is required to not infringe a third-party patent from a branded manufacturer. So, will the Supreme Court reinforce their requirement of causation? So back maybe to, if I go back to induced infringement, um, we've talked about in several cases um, that there needs to be some sort of something more than just knowledge. And here in the Grokster case, there was clear expression or other affirmative steps taken to foster infringement. That was decided in this copyright case. In Globe Tech, the affirmative steps to bring about infringement. So I think maybe what we're at least hoping for here is some clarity from the Supreme Court, um, which would probably be in line with the recent Cox decision if they sort of fell in favor of the generic holder, is that maybe this doesn't amount to causation or amount to anything more than just mere knowledge. Um, and I think it's possible that the courts are leaning that direction given their uh, lack of determination in the Cox case that just knowledge that the ISP had customers that were committing copyright infringement. That was not enough uh, to apply inducement in that copyright case. So um, there's three um, opinions that I wanted to. I read three very helpful documents. So the first was by Jacob Shurkow and Paul Gugliuzza out of the University of Illinois College of Legal Studies. They have a paper which is linked at the end of this presentation that I found very insightful. Their main argument, I think, throughout this paper in discussing GSK, the Amarin v. Hikma case that is currently in front of the Supreme Court, and the cases in between, is that the Federal Circuit um, has erred here in their interpretation of inducement. So, they say here, this is just an excerpt, but the Federal Circuit has effectively equated drug labels to patent claims for the purpose of demonstrating induced infringement. And that's kind of the thesis of their entire paper is that this is an infringement by a label, not by actions of a company. And they go on to lay out an argument that this is doctrinally factually wrong. It is uh, incompatible with the policy behind the Hatch-Waxman Act, um, and it provides patent rights holders with too much power and too much monopoly and more than Congress originally intended. That's kind of their thesis here. So, Shurkow and Guglielmo are hoping, I presume, that the Supreme Court decides in favor of the generic rights holder. So maybe a counterpoint to that, Dennis Crouch, who writes the Patent Leo blog, he, in response to this University of Illinois paper, published a paper that's also at the end of this presentation with the University of Missouri School of Law. And I think I don't need to read all of this, but basically, I don't know that Dennis Crouch feels in favor of the generic or the brand name squarely, but I think that his pushback on the University of Illinois paper is that if the circumstances are effectively set up, the market, the fact pattern I was talking about earlier, where the doctor and the pharmacist, they don't even see the Section 8 carve-outs or they're not aware of it, or possibly the pharmacists are actually forced to prescribe generic drugs for some other um, law or jurisdictional um, statute. If the market is all primed for infringement to take place, I think Dennis Crouch is sort of arguing in this paper that um, effectively, even if the generic drug manufacturer is complying by the FDA's requirements, and if they're not necessarily fostering that infringement, they don't need to. I think that's what Crouch is saying here is that they've recognized an opportunity, and I think I mean I don't know that this paper is entirely clear on this, but I think what Dennis Crouch is implying is that it would not necessarily be so unjust for the court to hold in favor of the brand here, and it wouldn't be the end to all Hatch-Waxman Section 8 carve-outs if they did. In the fact that this is a very unique case where, and I think he calls it a tinderbox. But basically, it was like we have a situation that is completely all set up. The market is very clearly all ready to um, take this generic drug and use it for off-label use, which infringes Amarin's patent. And so Dennis is saying this is a very unique situation. A holding in favor of the brand holder would not uproot all of the Section 8 Hatch-Waxman carve-out um, availability for generic drug manufacturers. Um, Also insightful and also linked at the end of this presentation, the AIPLA submitted an amicus brief on March 27, 2026 to provide some input in this Supreme Court case. And I think more than arguing in favor of either party, what AIPLA has said is there's no basis for the Supreme Court to read special protections into inducement law for Section 8 entrance, as the generic rights holder has asked the court to do. So they're pushing back on the generic manufacturer here. Section 271B, which provides induced infringement, is not only industry agnostic, but it's also flexible, adopting a categorical rule that excludes certain public statements made on a generic drug company's website, marketing materials, what have you, from qualifying as evidence of inducement would fracture the uniformity of inducement law and create a technology-specific safe harbor that Congress has not authorized. So AIPLA is actually arguing here that if the court does, as Hikma has asked them to do in their writ for certiorari, they are creating a safe harbor for generic manufacturers that is not authorized by Congress and would create um, industry-specific interpretation of induced infringement, which AIPLA does not feel um, is prudent here. So I think it's an interesting issue. I don't know that there is an easy answer as to what the policy should be in this fact pattern. I don't know if I have a ton more insight into what the ramifications would be if the court decided either way here, but I think it's definitely worth paying attention to what this decision comes out to be. Either as sort of a punctuation on a string of Federal Circuit cases, starting with GSK, that sort of eliminate the opportunity for a generic rights holder to use the Section 8 carve-out to capitalize on certain market situations where they know that their generic drug is going to be prescribed for off-label use that infringes a patent. So it's providing them sort of no guarantee that just because of their FDA language and the Hatch-Waxman provision that they escape uh, infringement. I think that it's possible that that decision could be read to sort of weaken what this Section 8 maybe was intended to do, which was actually to carve out and create, some might argue, a bit of a safe harbor. But in these fact patterns, I think we are actually seeing, if you look at sort of the sales figures and everything, like maybe one could argue egregious overuse of this carve out for gain in the marketplace. But on the other hand, I think it's possible and maybe even probable that the Supreme Court, as they sit right now and as they've decided recently, would not want to um, create any sort of passive um, induced infringement doctrine that would, could be applied to other practice groups and other technologies. And so, um, if I had to guess and just predict, I think based on the Cox decision, I think that it's likely the Supreme Court um, will either decline to clarify as Hikma has requested in the writ of certiorari. Um, but also, um, I think it is possible that they overturn the Federal Circuit's decision here and maybe either create some new law or apply old law in this context. So that's about all that I have in terms of the slides. I think we have a little bit of time to take any questions if anyone has any questions.
Very interesting, John. I thought you did a nice job laying out the landscape. We have a few questions here. First off, do you have any idea when the final decision is expected in Hikma?
I, I don't know.
Yeah, that's fine. Just curious. Okay, so here's some questions to get you to opine and think. There's probably no correct answers to some of these questions I've thought of. One thing I noticed is that the Solicitor General seemed to support the accused infringers in both Cox, the internet provider, and in Hikma, um, the the generic drug company, arguing for narrower secondary liability. Do you think that that's coincidental, like this case of situational advocacy, or do you see a coherent theory of secondary liability emerging from the government's positions across copyright and patent?
So I'll clarify, and I hope this is consistent with my slide deck, but the government had input on both of the pharmaceutical cases, so GSK and Amarin, not Cox, the copyright case. And so what I think maybe is happening here is, there's been a lot of industry pushback on overreach for pharmaceutical on-brand companies to extend the life of their patents, extend the scope of their patents, and of course, there's been a lot of scrutiny in the last decade for blocking generics from entering the market. And so I think that um, in this industry, it's not surprising to see the Solicitor General providing some input here and pushing back on Big Pharma and saying, um, look, we're not going to expand secondary liability beyond what the statute says and what the courts have decided in the past here. Um, I think that's all the Solicitor General has said, which is a lot less than than Hikma has said, which is basically expanding or finding us liable for induced infringement here would be incongruent with the Hatch-Waxman Act. I think what the Solicitor General is saying is that, and I'm going to go back to the quote, which I found interesting. I think this is the big takeaway from this oral argument is the Solicitor General saying, well, here's two hypotheticals that I think would be a strong case of active inducement. So I don't even think that the Solicitor General is completely one-sided here, as much as they are in both GSK, which the Supreme Court declined to review, and here, which they did. Um, the Solicitor General is arguing that, you know, here is where the line ought to be, or please clarify where the line ought to be, but it certainly cannot be in this very unique fact pattern where there's no evidence that Hikma in marketing materials or whatever encouraged use, which is maybe against what Dennis Crouch is saying here, which is that they didn't need to. The market was so primed for this, given the timing and everything, that it's like they definitely knew. Like we all know that they knew is kind of what Dennis Crouch's standpoint is saying. I don't even think that that's not really how the Solicitor General feels about it. Solicitor General submitted a brief in December 25. You guys can go check that out if you want to maybe get a little more insight into where the government is following on this sort of fact pattern.
So John, put yourself in the shoes of a generic manufacturer preparing to launch under a Section 8 carve-out tomorrow. Setting aside how Hikma ultimately comes out, um, w- what would be your recommended practices for press releases, sales rep training, product catalogs, and dealings with pharmacy benefit managers to minimize induced infringement exposure right now? I mean, in your eyes, after reviewing everything and the current landscape, are there practices that used to be routine that you would now counsel a client to abandon, for example?
Yeah. So I actually 2 weeks ago, a couple days after this decision, I was in Los Angeles. I was listening to corporate counsel for a couple large pharmaceutical clients, or not clients of ours, but large pharmaceutical companies provide some input on this issue. And I found it really interesting because what they were saying, and I won't, say what companies that they worked for, but large, well-known drug manufacturers saying that these parts internally for some of these generics, uh, they are walled off. The marketing people don't necessarily have everything reviewed by their in-house counsel or their IP team or anything. And so I would say the biggest takeaway from hearing how their biggest takeaway, which I would repeat here, is that after GSK, after these federal circuit decisions that are possibly pushing back on this perceived safe harbor of the Hatch-Waxman Act, that everything must be reviewed. Marketers are going to market. They're going to sell the drug effectively, but I think I would tread with a ton of caution after those decisions. I You said regardless of how this Supreme Court case turns out, I think it's unlikely that the Supreme Court very squarely rules in favor of the generic, where they create a doctrinally sort of defined safe harbor here. And so even regardless of this decision, I think the one takeaway from looking at all these cases and reading through all this commentary and even talking to some of the folks that are working in these industries is that you just can't be too careful in your marketing materials. And the Hatch-Waxman Act is not some immunity shield against any accusation of induced infringement.
Well, very interesting, John. And I certainly could ask you more questions, but unfortunately, we're at the end of our hour here. So thanks very much for all your work on that. And again, I thought you did a fantastic job. Kind audience, if you have any additional questions, please feel free to email John or myself. We love to get emails. And again, a link to the slides for today's presentation will be emailed to you in case you don't have those. I hope that you will tune in to additional episodes of the SLW Chemistry and Biology Seminar Series. We are planning to give one more episode, the last episode of the season, next month. So please tune into that. And thank you very much for your attention today.
Thank you.